morning. I'm Chief Judge Davis. To my right is Judge Peach, and to my left is Judge Allen. We're here today in the matter of John R. Ratzer against Robert Wilkie, Secretary of Veterans Affairs. Docket number 18-0107. We're here to consider generally whether entitlement to service connection on a secondary basis can arise before the effective date of the award of service connection for the primary condition. Would counsel for both parties please state your appearance for the record?
Your Honor, Patrick Berkshire for the appellant and Stacey Schrumpel.
Morning.
Mark Bitchich appearing on behalf of the Secretary, and with me at counsel's table is Nicholas Esterman.
Good morning. Are both parties ready to proceed?
Yes, sir.
Each party will have 30 minutes to present your respective arguments. Counsel for the appellant, do you wish to reserve any time for rebuttal?
Yes, Your Honor. I would like to reserve 10 minutes for rebuttal.
Very good. Thank you. You may proceed.
May it please the Court. The result in this case is controlled by your decision in Delicio. In Delicio, the veteran filed a claim for peripheral neuropathy. While that claim was still pending, Mr. Delicio filed a service connection claim for diabetes. The evidence ultimately showed that the diabetes was the primary condition, i.e. the condition that caused the peripheral neuropathy, the secondary condition. Now, in that case, VA argued that the effective date for both conditions, the primary and the secondary, could be no earlier than the date on which the primary condition had been filed. However, the court held that if after filing for a secondary condition, it becomes evident that the secondary condition was caused by a primary condition that was related to service, that the filing of the secondary condition counts as a filing for service connection for both conditions, even though the veteran did not file service connection for the primary condition until years later. Therefore, Mr. Delicio could get an effective date for both the primary and the secondary conditions retroactive to the date of filing for the secondary claim, peripheral neuropathy. This assumes, of course, that both the primary and the secondary conditions became manifest on or before the date of filing. In this case, the secondary condition is a blood disorder, and the primary conditions are PTSD and liver cirrhosis. As in Delicio, the claim for the secondary condition was filed before the claim for the primary conditions. The Secretary argues that Mr. Ratzer did not appeal the effective dates for the primary conditions, and that means that Delicio is inapplicable to this case.
So on that point, right, isn't that a... So first of all, in Delicio, Mr. Delicio did file a formal claim for hypertension, is that right?
Your Honor, are you referring to the cirrhosis, the blood disorder, or the PTSD?
I'm actually referring to Delicio.
Oh, Delicio.
Right, so...
that was neuropathy, Your Honor.
Well, it was neuropathy. He filed a formal claim for neuropathy. I don't think he filed a formal claim for diabetes, did he?
He ended up filing a claim for diabetes, but I believe it was an informal claim that was developed, Your Honor.
So my point is, though, in a major distinction between our case and the Delicio case is in Delicio there was no decision that remained final and unappealed. In other words, it wasn't as if in Delicio the board denied something for hypertension and then that wasn't appealed, right? But here we have the complication that there is a denial that then became final. And so I would like you to address why that doesn't matter, because I'm assuming you think it doesn't matter, that difference is not important in terms of whether Delicio applies.
Absolutely, Your Honor. Although we would not necessarily concede, actually we do not concede in this case that the decision was final, we believe if it is final, that it does not matter with respect to the blood disorder. And the reason that it does not matter with respect to the blood disorder is when you look at Delicio, the holding with respect to effective dates is we're looking for when the conditions manifest. So there isn't some sort of legal requirement where, because an effective date was perhaps inappropriately set for one condition, that now binds the court or VA with respect to the secondary condition's effective date under 3.400.
So let me ask you a slightly different question. So as I understand it, basically we have a filing of the claim for the blood disorder in about, 2008? Is that right?
Yes, Your Honor.
And then leave aside the PTSD for a second.
Of course.
We have then a submission of something in June 2012.
Yes, Your Honor.
So the VA construes that submission as a claim for the liver condition, right?
Yes, Your Honor.
So what do you think about the fact that that itself might be an error? In other words, is it possible to read Delicio to say everything was on the table because of the filing of the blood condition? So when the submission comes in June 2012 that says, hey, I thought my blood condition was related to Agent Orange, but now my doctor's telling me it's related to cirrhosis. One way to look at Delicio is you didn't need a claim. That was evidence that the VA should have followed up on to see whether, under Delicio, the blood disorder was related to the liver, and then maybe the liver is related to something else. So what's your reaction to that?
Your Honor, I'm glad you asked that question, because I actually think that you're pretty close to on target right there. Because...
Well, thank you. I recently went axe throwing, and so I'm doing better today than I did in that. Let's put it that way.
Your Honor, we didn't specifically brief it in the appeal, but there is an argument that under Delicio, everything was on appeal back in October 2010 when the original NOD was filed, because the claims for PTSD and liver cirrhosis were already reasonably encompassed by that first filing. And that VA should have developed this all as one claim instead of breaking it apart in that SOC that was filed after the substantive appeal. And so it is our position that, yes, under Delicio, we could argue that everything is on appeal, and that there hasn't been a board decision with respect to the PTSD or the liver cirrhosis, and that is one way that this case could be resolved, Your Honor.
Mr. Berkshire, walking backwards, we have the blood condition that's undefined in 2008, alcohol-related cirrhosis in 2010, and PTSD in 2011. This whole area of effective dates is complicated, in my view, and it's a bit counterintuitive to associate a secondary before a primary. But our law, Delicio, says you can do that, as well as Frost. How would you, assuming the court does not accept your argument, what option would you have in this situation?
Your Honor, if the court were to reject all of our clients' arguments with respect to this case and uphold the board's decision, under Delicio, I believe there probably would be an opportunity for Q with respect to the PTSD and the cirrhosis. Obviously, our client would prefer not to go down that road, as Q is an onerous standard, and because you're challenging finality, very difficult to pursue. But I believe there is potential there given the state of the law.
Very good.
Now, Your Honor, under the Secretary's argument, Mr. Ratzer essentially is a victim of a procedural trap. The trap is, while his claim for a blood disorder was pending, he filed claims for PTSD and liver cirrhosis that were unnecessary because those claims were already encompassed by the blood disorder claim.
So I agree with you entirely, but the next step is then, okay, so what do we do about that? Because it really is odd that had he just filed the 2008 claim for the blood disorder and sat back and done nothing else, and during the course of development, we find out about the liver condition, and then we find out that the liver condition is related to PTSD. My reading of Delicio is he didn't need to do anything. But the reality is he did something, and then VA reacted to what he did. So just assume that you would have then, your client would have had to appeal determinations about, say, the PTSD or the cirrhosis. Let's just, I know you disagree with that, but just assume that because VA acted, you would have had to take a step to put those into appellate status. But the steps you would have taken are with respect to decisions that never needed to have been made because you never needed to do what you actually did. So what do we do with that conundrum there?
Your Honor, I'm actually glad that you asked that question as well. You're really on point today.
And my tie is very nice too, isn't it? So there we go.
It's an excellent ingredient. So what we'd actually look at is we brief this pretty thoroughly, and it has to do with how VA construes the filings that a veteran submits after this separation has taken place.
What do you mean the separation? Do you mean after they have another claim that's out there and they treat them as separate, you mean?
Exactly,
Okay.
when they issued the separate decisions on the individual claims, Your Honor. Now, the Secretary essentially contends that even if Mr. Ratzer had initially been entitled to the effective date before June 2012 for his cirrhosis and the other conditions, that he lost it because he did not successfully file an appeal to the effective dates for those claims. But the truth is the decisions never did become final because the next month Mr. Ratzer filed a notice of disagreement. And it expressly mentions each disability, Your Honor. I mean, it sets out the blood disorder, the cirrhosis, the PTSD, describes the causal chain, and refers to and attaches over 30 pages of medical documents laying out how these symptoms have been around for decades. In essence, the veteran offered up the Delisio principles on a silver platter with this NOD. And all that was required for VA to avoid the problem that we have right now was to look beyond the four corners of that NOD and read what he said, what he referred to, and what he attached. And if the VA had done that, if it had followed up on its duty to investigate, it would have been clear that June 2012 was not the proper effective date for the cirrhosis, or the PTSD for that matter, Your Honor.
So this is a strange question in some respects. So assume one of us, and this is a good assumption, one of us will have to write something about this. And so I understand what you want the end result to be, right? Your client, Mr. Ratzer, wins. But there are potentially different ways in which that can be done. Which one do you think the court should do if you had to have only one pick?
If we were going to narrow this down to exactly one lane, Your Honor, I think that the court should hold that in October 2010, the original NOD placed everything into appellate status, and until the board actually issued a decision concerning each issue, it was impossible to separate them out, and these are all still live claims. That's what I would have the court hold, Your Honor. So, getting back, we've already covered the cirrhosis when answering the question so kindly offered by Judge Allen. But now let's move on to the PTSD, because that's even a little more different since there was a claim filed independently before the substantive appeal arrived. Now, what I would argue, and what Appellant argue, is that the same concepts that we talk about with respect to the actual NOD would also apply to the substantive appeal. In that substantive appeal, in box 10, the veteran once again names every disability, the blood disorder, the PTSD, the liver cirrhosis, says how he's been suffering from his PTSD symptoms for a long time, and then once again refers to medical evidence supporting the existence of his symptoms for decades. Reading that document broadly brings up that there is a problem with the effective date for PTSD, and the PTSD decision was not yet final when that June 2012 substantive appeal was filed.
Counsel, if you look at box 9, the appellant doesn't say anything about PTSD, right?
He says it in box 10, Your Honor.
I said, if you look at box 9, the appellant doesn't say anything about PTSD. And box 9, could you read box 9 for me?
In a second, Your Honor, I need to make sure that I
Take
have
your
that in
time.
front of me. Yes. Thank you for the patience, Your Honor.
No problem. I'm very patient.
In box 9, he checked box B, which says that he read the statement, and then he wrote, I wish to appeal the denial of the blood disorder as due to my liver, not herbicide exposure.
So what does 9 say, the sentence right after the number 9?
The number 9. Oh, you mean on the form itself, Your Honor?
Yes.
These are the issues I want to appeal to the BVA.
Okay. And then he checks section B in that box, right?
Yes, Your
It
Honor.
says nothing about PTSD.
No, Your Honor.
Okay. You may continue.
Do we, so what basis do we have to, I think I know from what you just said, not to Chief Judge Davis right now, but right before that, if we were going to write something about PTSD, on what basis would we do that, given the board's decision here, which didn't really talk about that?
So with respect to the PTSD, because the board did not address it, it would have to absolutely be remanded for the board to address that issue.
Well, but so it's sort of funny. The way your brief was on this point was a little odd, because normally it's the board erred because it did X, or the board erred because it didn't do X. Your argument about PTSD is if you send this back, you have to remand it anyways. Why don't you mention to the board that they might want to consider something about PTSD? That's fundamentally the way I read your argument. We don't usually do that, right? We don't usually just say, you didn't talk about something, but we're not telling you it's error, but why don't you think about it anyways, right? So am I missing something that the board actually did?
Your Honor, I actually would say that the board did err. And although this was not raised in our briefs, because all of these issues were still on appeal, there was an obligation for the board to finally make a decision on it and deal with that appellate issue. And I would say that, once again, the Delicio effective date rules and the Delicio service connection rules were repeatedly raised by this veteran during the appeals process. And it was a pro se veteran the entire time.
So one thing maybe for you to think about, you can respond a little bit on rebuttal, if you want to think about this, is, and I haven't thought through this, but as you just said, you actually didn't make that argument on appeal, right? So I'm wondering, just from the veteran's perspective, whether it's actually inures to his benefit to say that that was an argument that could have been made as opposed to not, right? Because if you could have made that argument in your brief and you didn't, then we've got law that says you've waived it, which then binds you on remand, as opposed to the alternative, which is we just don't say anything about PTSD because it really wasn't before the board, and you can make arguments on the back. So I'm just throwing that out there, right? That's a big division line potentially.
Your Honor, you are absolutely right that there are complications, and that is perhaps a remedy that could work for the veteran as well. But I would also maintain that the court still has jurisdiction over the issue, and although it certainly would be possible to construe our pleadings to find that there was a waiver, the court is not required to do so. Therefore, I believe I've covered all the bases, Your Honor. So if there are no other questions, the position of the appellant is the court should reverse the board's erroneous finding that the June 2012 was the proper effective date for the blood disorder, and order an effective date of November 2008 be assigned, or alternatively, that the claims are remanded for the board to determine when the disabilities first manifested under the Delicio standard. Additionally, although Mr. Ratzer maintains he is entitled to a November 2008 effective date for PTSD, at a minimum, the court should vacate the board's decision and remand this case with an order for it to address whether the June 2012 substantive appeal was an NOD with respect to the effective date for PTSD. Thank you, Your Honor.
Thank you.
Good morning, Your Honors.
The Secretary today is asking the court to affirm the board's denial of an earlier effective date for a service-connected blood disorder and to affirm the board's dismissal of an appeal for an earlier effective date for alcohol liver cirrhosis. There are two legal issues presented, and the Secretary is asking the court to hold first that the effective date for a secondary condition cannot, as a matter of law, be earlier than the effective date for the primary condition. And second, the Secretary is asking the court to hold that the appellant's August 2013 notice of disagreement did not constitute a disagreement with the effective date for the alcoholic liver cirrhosis.
I understand you to say Delicio is incorrect?
No, Your Honor. Delicio relieves the veteran from having to file anything separate to establish a claim for the primary condition. Delicio did not hold that the effective date for a secondary condition can be earlier than the primary condition. The veteran has been service-connected for all conditions. So the issue here is not whether he is entitled or whether he is required to file any specific document. The issue here is when the date entitlement arose. So the issue here involves an interpretation of 3.400. And the date entitlement arose, it requires looking at the underlying regulation under which service connection was granted, which in this case is Section 3.310. Section 3.310 requires an underlying primary service-connected disability before service connection for the secondary condition can be established. And that's why the Secretary is asking to hold that a service connection award for a secondary condition can never take effect before the primary condition service connection award has taken effect.
That seems somewhat inconsistent. If we were writing on a blank slate, I might be with you, if only for the fact that I have trouble grasping the idea of something that's second coming first, right? Which is fundamentally what Delicio says, although it sounds better in Latin, right? But here, Delicio says, right, that you're right, perhaps technically, but in the holding section, but it describes the question as whether a secondary condition can happen first, right? I mean, I don't know how you can read Delicio to say what you just said.
Well, Delicio doesn't control here, and we're not arguing that it does. All that Delicio says, at least for purposes of this case, is that the veteran was not required to file a separate claim for the alcohol liver cirrhosis or PTSD. So he was not required to. But even though he did, once the regional office granted service connection and an effective date, then determining the date entitlement arose for the secondary condition was necessarily dependent on the effective date for the primary condition.
What if he had never filed anything other than the blood disorder claim? So in other words, he files the blood disorder claim in 2008 or 9 or whatever that is. VA finds out along the way that a doctor says, well, the blood condition's related to this liver thing he's got. And then another doctor says, oh my goodness, the liver condition's related to PTSD, right? So under that scenario, and nothing else happens, no decisions are rendered, okay, just development of the claim, then would you agree that under Delicio, all of those conditions could have the effective date of 2008?
Could have, and that's exactly the point, is they could have, but we don't know what would have happened if the regional office had not treated these as separate claims. So yes, under Delicio, they certainly could have gone back to 2008.
All of them, right?
Yes.
Okay, so then we have the situation, let's just stick with the liver claim for a second. So VA gets, so you'll agree, right, that the blood disorder claim has been on appellate status the entire time?
Since 2008, yes.
Right, so that ball has always stayed in the air, right? Okay, so the veteran then submits this thing in June of 2012, right? Why, if under Delicio, why would VA treat that claim or that submission as a claim? I agree with you. 99 times out of 100, a veteran's better off if VA construes something as a claim, except here, where construing it as a claim is what started us down, at least with the liver condition, down the road that led to, John Marshall Law School today. So why wouldn't we say that the board or that VA committed error in the way it construed that as a claim instead of construing it simply as evidence to develop under the Delicio standard?
Well, the Secretary will concede that it was an error to treat that as a separate claim, as opposed to a component of the claim that was already being developed. And the board acknowledged that when it said that this has been pending since 2008. The difficulty here is that when the regional office granted service connection and an effective date, the veteran filed a notice of a disagreement, which disagreed with one but not the other.
But of course, under VA's view at that, which you interpret, the VA interpreted that NOD as applying only to the blood disorder, not liver, right?
Yes.
And that's one of the issues Appellant raises, right? But and I agree that if you just read the four corners of that, it's hard to read it to say liver, right? I mean, it uses the words, but not in terms of this is what I disagree with. But it seems to me that under the Secretary's view, not you personally, but the VA interpreted that NOD in a way that made it impossible for the veteran to actually prevail on his claim, right? Because under the VA's view, without challenging the liver condition, he could never prevail on his claim about the blood disorder, right?
Yes.
Well, doesn't that just strike you as weird, right? In other words, in order for the veteran to win under the VA's view of the law, let's just assume it is, he had to appeal A and B. He mentions A and B in the thing, not in the most developed way. So VA has to make a call about what's on appeal. You only say he appealed A, even though your view of the law was if you didn't also appeal B, you never could win on A, and you don't tell the veteran that that's the way you're understanding the law, right?
So the difficulty here, the Secretary's primary concern, it has to do with the system as a whole. And this is why Section 20.201, in effect at the time, required when a rating decision is issued, the veteran is required to identify the specific issues he or she wants to disagree with. And that's why the rating decisions list issue 1, issue 2, issue 3, etc. In fiscal year 2013, the VA received over 118,000 notices of disagreement. And in response to each of those, VA was required to issue statements of the case which addressed the specific issues to be appealed. And the Secretary's ability to fulfill that legal obligation to every veteran who's attempting to appeal a decision is dependent upon the veterans simply identifying issue 1, issue 2, issue 3, or so on. So it's I have some sympathy, and I'm not saying that in a joking way, with the Secretary and the volume of work that comes in the door. There's no question about that. But here, it's hard to ignore the reality that the only reason we're dealing with this NOD and what it means is because the VA committed error by construing this as a claim in the first place, right? I mean, because the veteran never should have had to disagree with anything because VA shouldn't have treated this as a claim. He had already perfected the appeal to the blood disorder that encompassed under Delicio all of these other things, right? I just want to ask your clarification. When you say he already appealed the blood disorder, are you referring to the 2013 NOD or the 2010 NOD that my colleague referenced earlier? Because I just wanted to make a point about that. The issue there was service connection. Service connection has been granted for all the disabilities. The effective date is a downstream issue. So that 2010 NOD cannot give this court or the board jurisdiction over the issue. It would have to have been the 2013 NOD.
But you agree that if all we had was the filing of the blood disorder claim, and then VA gets this thing in June 2012, right, that it construes as a claim, right, for the liver thing, the liver condition, right? If VA would not have construed that as a claim, but would have said, oh, wow, look at this, under sort of the Delisio logic, we now have to develop to see whether or not the liver condition itself is connected, right, which would arguably then lead to PTSD and all of that. But it's that moment in time that I want to focus on, because if that's a mistake, why should we then penalize the veteran for the mistake the VA made? Because later, let's just assume the veteran himself makes a mistake when he disagrees with a decision that never should have been made, at least based on construing something as a claim.
We'll offer two reasons. First has to do with 20.202, which, yes, it was an error to treat the claims as that way, but once VA issued the rating decision and the separate effective dates for each of those conditions, the Secretary's regulation, 20.201, required the veteran to appeal both of those if that's what he wanted to do. And that rule exists for a reason. It's so that the Secretary can assure efficient functioning of the system. The second point I wanted to make is to draw your attention to page 107 of the record, and that's the February 29th, 2016 statement of the case. And the regional office said that we cannot grant an effective date for a secondary condition which is earlier than the effective date of the primary service-connected condition which caused or aggravated it. Now, that was after he had already filed his NOD, which in hindsight, he probably wishes he would have appealed both. But the regional office put him on notice that you cannot get the earlier date for this condition because the effective date, you only appeal because the effective date is tied to the earlier condition. He never said, oh, no, wait, I wanted to appeal both, or I didn't know I made a mistake. Had I known that, I would have tried to appeal both. He still didn't clarify what he was trying to appeal from his NOD. And that's why we agree that an NOD is not to be viewed just looking at the four corners of the document, but in context of the record itself. And if he had said something to clarify that what he really meant was both conditions, then that would be something that could be taken into account today. But even after putting him on notice that the effective date for the blood disorder was dependent on the effective date for the alcohol liver cirrhosis, he still did not express any dissatisfaction with the effective date for the alcoholic liver cirrhosis.
So have you, this is a little bit out of the box, and so if you can't answer it, that's okay. So it just strikes me that, leave aside the legal stuff and the facts in all of this here, it does seem like there's a fair bit of mistakes floating around on both sides of the aisle here, right? And I would say of most of the cases I've had in 2+ years now, this is one of the most procedurally Byzantine cases I have had. I mean, it's taken a lot of time to figure out what happened, what should have happened, somebody doing something that they didn't have to do, but then comes back to bite them because they did more than they should have done. Right, it's a weird situation.
I'm glad you said that because that's how I feel too.
Great. I'm going to go back to the axe throwing, I'm telling you, but have you thought, the department, the government, have you thought about maybe there is a way to resolve this? Because here's the thing, right? We're going to say something about the law, and if we write a precedential decision, I don't know what that's going to be, and I don't know whether I'll be, writing this or dissenting or whatever. But the court's going to say something, and it just strikes me this is one of these situations where the old adage of bad facts making bad law. I'm just wondering whether there has been any thought of that to say, God, for Mr. Ratzer, this person who served the nation, we both sides made mistakes here. I'm just throwing that out there as a thought.
The secretary is always open to that possibility, and he has resolved cases post-oral argument under similar circumstances.
So just hypothetically, right? If when we finished here, my colleague, the chief judge, instead of saying that the case is submitted for decision, were to say something like, we will hold submission of the case for 14 days, and then the case will be submitted if we don't hear from the parties. Would that be something that would be objectionable to you?
No, absolutely not.
And I'll ask the appellant's counsel.
The secretary would, regardless of the case, would always be willing to do that. Yeah.
Well, and I understand there are times where I have another case coming up in which the dispute between the parties is $8.51. But there are principled reasons why that legal issue needs to be resolved, and I get that fully. Here it's just so complicated and messy because of the weirdness that I thought this might be something to at least throw out there, and I haven't conferred with my colleagues.
But your point is taken, and we will certainly take it under advisement.
Mr. Vicich, let me ask you, you said something that interests me, because I came into the court session today thinking the law was one way, and to me it was counterintuitive, because to think about a secondary condition existing before a primary condition, that's just not logical. But as I understood Delicio and Frost, that is what the law seems to allow. But you basically said that's not the case. Did you not, or did I misunderstand?
I don't recall making that point. I don't think I was trying to make that point.
Okay.
Well, the point I was making here is if Frost and Delicio are factually different. They didn't discuss, or Frost in particular does not discuss 3.400 and the date entitlement arose. So that just wasn't an issue, and it's just not helpful here. Frost would maybe help determine whether service connection for these conditions are warranted, but we already know is entitled to the service connection. The issue is when. When did entitlement first arise? And and that's why we looked at the underlying regulation, 3.310. You need a service-connected disability, a primary service-connected disability, for there to be a secondary service-connected disability. And for the effective date principles, our argument is that until that primary condition takes effect, the secondary condition cannot take effect either. And for example, the court's, the Federal Circuit's decision in Young and Ellington addressed that point. They looked to the underlying entitlement regulation to determine when entitlement arose. In one of those cases, it was 3.04F.
Right.
And that's the point. We're just analogizing those cases by pointing to 3.310.
I have a question. In your opinion, in a normal, run-of-the-mill, very simple, straightforward claim, when, in your opinion, does Delicio cease to apply? In a regular claim, you file for a claim, investigation takes place, the decision is made, blah, blah, blah. When does Delicio no longer apply? When would the VA have to say, I don't need to expand my investigation into?
Judge Peach, under the under the legacy appeal system, it would apply throughout as long as that claim is pending. If a claim is going, for example, 10 years, and which is unfortunately it happens, these claims can go on for quite some time. If a theory is raised at a late stage in the game, the system allows that. I mean, that's one of the reasons the appeals process can be so drawn out, is that new theories of entitlement can be raised at any time, and VA would have the duty to develop that. So if the veteran filed the claim for a blood disorder and years go by, and then it was, if assuming VA was correct the whole time, and there was no evidence to link it to service, but then after years have gone by, we discover, it actually is related to service by way of this intervening condition, the liver cirrhosis, PTSD, that theory, that way to get there from one condition all the way to service would be a viable theory throughout the claim.
Isn't that what happened here?
Well, what the difference here is that the assigned an effective date and that decision became final. Because again, the entitlement issue is jurisdictionally separate from the effective date issue. So once the regional office assigned effective date, put the veteran on notice, here's the effective date for your award, here's your initial rating. If you're dissatisfied, you need to appeal. And then he came and said, well, I'm only going to appeal. Well, it wasn't as clear, but he identified one issue, but did not clearly identify the second issue. So, and that's why the Secretary is arguing that the effective date of that second issue became final once that appeal period expired.
So in your opinion, if this had been a claim originally, instead of saying I have a blood disorder, and what he said was because of Agent Orange, that's what started this whole thing.
Yes.
If he had said I have a blood disorder, and it's because I got this liver cirrhosis, nothing about PTSD, nothing about that, would that have been a simpler case for Delicio to apply? Because they would have to explore the cirrhosis, and that would lead maybe, in this, as it did in this case, to self-medication because of PTSD, and PTSD became the primary reason, and therefore he would be connected for cirrhosis, and he would be then therefore connected for his blood disorder.
If that had happened, it's very plausible that the regional office would have treated those and applied Delicio back then, because that's the key. If they would have identified those theories early on, then we probably wouldn't be here today. It was when that theory was later raised, then they erroneously, the Secretary is agreeing, that it would erroneously treated it as if it were a new claim, and that's where the case got complex. Yeah. But we don't know what would have happened. We can only look at what did happen here and what the law says the result should be here.
Mr. Richards, what would or should have happened had the Secretary not treated I guess it was an NOD as a claim?
Well, the submission of evidence thing?
Right.
Right, okay.
I think, Your Honor, Chief Judge Davis, you're referring to the June 1st, 2012 VA-9 that they treated as an appeal for the denial of service connection on a primary, a direct theory, but then they treated it as a separate claim for service connection for the same condition under a secondary theory.
I think that's
and the law says that the primary direct service connection and secondary service connection are just different theories. They're not separate claims. So, and again, we agree that it was erroneous to treat that as if it were an entirely new claim. It was really just a new theory in support of the same claim, which by that time had been pending for approximately 4 years.
So let me ask
what
you.
What would have happened? We don't know.
Let me just ask you. So, would after having treated that as a claim, okay, erroneously treated it as a claim, then there's a rating decision, right? After that?
Yes.
Okay. And then it's that rating decision that is unappealed as to that issue. Is that right?
They granted service connection and then assigned the effective date.
Right. And so it's the part of that about the effective date, right? So hypothetically, though, wouldn't the appellant still be able to go back and allege, I'm not asking you to take a position on the merits, but that would be able to allege clear and unmistakable error in that decision? In other words, that it was clear and unmistakable at the time that that you shouldn't have treated this as a claim in the first place?
The difficulty there is that it's not a final decision. It's as for the effective date for the one is a final decision, as the effective date for the other is the one that led to this appeal. It is an option, as my colleague pointed out. It's an uphill burden for him to meet, but it is an option.
But, right, and again, I'm not asking you to take a position on this, but that's one of the reasons why I raised the point about the discussion, because I can't think of a reason why the board could have construed this, the RO could have construed this as a claim under the Delisio logic. I just can't think of any reason under the law that would have been that way. And so, again, I'm not asking you to take a position on it, but I did want you to tell me, which you have, whether or not the Q avenue was still open as to that as far as you think, and I think you've said it is.
Well, yeah, there's no time limit.
Right, and he hasn't raised that before, so he's okay.
And it would be a separate collateral attack, and it would still have to, if that were denied, have to go up through the board. So it's outside of the scope of this appeal today, but it is one procedural option that he has.
And had this not been treated as a claim, there would have been, I assume, some additional investigation on the theory here. Is that right?
Yes, Chief Judge Davis, and in fact, that would be ultimately important if the court were to reverse the board's decision, and because the board would still need to determine, based on the facts found, which condition was first or when it started. So the Secretary wouldn't concede that the effective dates for all these conditions would go all the way back to 2008. But in your the question you presented is, yes, so the RO would have done some additional development and said, well, let's look into this cirrhosis PTSD theory, and then figure it out from there. The Secretary has no other questions, or excuse me, the Secretary has no other points to make. If the court has no further questions, the Secretary will. Yes, Judge, please.
Mr. Ratzer filed in his original claim in November 2008. And when was he diagnosed with the cirrhosis, do you know?
2010, he had been experiencing some symptoms, and he had undergone some tests, and they were inconclusive in the 2006-2008 period. And then it was a VA doctor, and it was about summer 2010 that confirmed the diagnosis. And there's page 529 of the record is one piece that establishes that diagnosis.
And if we were to be sending this back, basically, that's where then the board would need to discuss how Frost plays into that piece, right? Frost saying a condition doesn't need to be diagnosed or anything, right? I mean, that's where the sort of sequence that came out of your discussion with Judge Peach a moment ago, that, he had the blood disorder and then the first diagnosis of the liver is after. That seems to be what Frost is all about, and nobody had to wrestle with that given the weird procedural complexity here, right?
The board or the regional office would need to make some fact. It would be more of a fact question. And I do want to clarify one point. In our brief, we argued that the effective date issue was a factual issue. In many cases it is, but in this case it's not. I just want to clarify that it's a question of law that we're presenting. We're not asking the court to defer to any factual findings the board made. So just wanted to clarify that.
Mr. Vichich, one other question. If the court were to not submit this case for decision for a period of time, as Judge Allen suggests, how much time, in your view, under these circumstances, would be reasonable for you to confer with the other side?
Judge Allen, I believe, suggested 14 days.
Right.
That's very reasonable.
Okay.
Excellent.
I guess he got the mark on that one. Very good. Thank you. Mr. Berkshire, your rebuttal, and I'd ask you to start with the question I just asked Appellee's counsel.
Thank you, Your Honor.
Yes.
I also believe that 14 days would be a reasonable amount of time for us to consult with the Secretary if their position on the case changed.
Very good, thank you.
Your Honor, there's not a whole lot for us to say here, but I do have some specific points that I would like to rebut. First, with respect to the Secretary's argument that 3310 is having some sort of legal binding effect on figuring out when entitlement arose under 3.400 for the purpose of an effective date. From Delicio's language, we know that that really isn't the case. What you're looking for to find out when entitlement arose is when the conditions manifested. So you take all the evidence in, and you look at it, and it's like, when did the conditions manifest? And that could have been before evidence was submitted. It could have been after. There is no legal control. I mean, the Secretary talks about Appellant, but the Federal Circuit rejected the idea that the regulation for establishing secondary service connection controlled how you determine the effective date. Now, in that case...
Could I just one point on that? So, clearly under Delicio, if it means anything, it means that you file for a secondary condition. You never have to file for a primary, but if along the development we come to find there's a primary, then all can go back potentially to the original filing of the secondary claim, right?
Yes, Your Honor.
Okay. Is there a scenario under, and this gets to the Secretary's point that he started out with that I think the Chief Judge asked, is there a scenario in which, in your view, under the law as it stands, I can have primary condition A have an effective date of in 2017, but secondary condition B have a effective date earlier than 2017? Is that possible?
Yes, Your Honor, that could be possible. For essentially, the only way I could see it being possible would be a situation like this where somehow VA was wrong about the effective date and that assigned effective date became final. But when looking at the factual question about when the disability arose or when it manifested, it turns out for the secondary condition, yes, it was earlier.
So in this case, and that your answer was precisely about the next question, which is, so if we were to assume, right, that the PTSD decision, let's just say, final, unappealed, okay? So it could never have a date earlier than whatever the date was assigned.
If it was final?
Right, so let's just assume that, right?
Yes.
Your argument would be, but that doesn't make the board's error that we're assuming about the liver condition, okay? That doesn't make that harmless because it is possible to have the liver condition and the blood disorder claim get an effective date that's earlier than PTSD. It just won't happen very much, and this might be one of those very rare situations where it can happen.
Yes, Your Honor. In a situation in which we assume it's final, there's nothing you can do about this effective date, you're stuck with it, you can still get the earlier effective dates for the secondary conditions that remained on appeal, Your Honor. The next point that I wanted to address was the issue about how to construe the notice of disagreement. The August 2013 is. I think that it's instructive to look to the Federal Circuit's decision in Shea recently about how we look at the pleadings that are submitted by pro se veterans. The truth of the matter is the veteran is pro se in this case and put forward all of the facts and information necessary to invoke Delicio without knowing that Delicio was around to help him. And Shea is pretty clear that when a veteran gives you a document and it says one thing on the document, but it references other information, that you have to look at that other information when construing the veteran's pleading. The board didn't do that in this case. They narrowed their analysis to just the sentences on the NOD. And I think if you look at the information referenced by the veteran and the fact that he raised the causal chain, Delicio was an issue, and reasonably that NOD should have been reasonably construed as an appeal of the cirrhosis.
And what about the argument that, and this is what I mean about, missteps along the way. It's almost as if the two sides, and I understand Mr. Ratzer was pro se, but it's almost as if they traded errors. It's like I make an error, you make an error, it's my turn to make an error, because so they make a mistake about the NOD, as you say, and then they say in the SOC, this is how we're understanding the world to be, and Mr. Ratzer doesn't say anything back, right? So what's the argument then about that? That even if they misconstrued it, they said, this is how we're misconstruing it, and Mr. Ratzer doesn't say anything like, no, that is a mistake.
Your Honor, I would say that under Delicio and Shea, that a certain burden has been placed on VA to investigate when the veteran has submitted these pleadings, because VA is supposed to be trying to maximize benefits, not just win the case. Because, yes, the veteran probably made a mistake here, but it's an understandable mistake, and it was very, very possible for VA to avoid the error, and they didn't. And that would be my response, Your Honor. If there are no other questions?
How do you interpret that letter from VA to Mr. Ratzer about the fact that VA lost the original paperwork for his appeal? And does he still wish to appeal the blood disorder? And if we don't hear from you, then that's what we expect. Can you talk to that?
Yes, Your Honor. I think that 2015 letter is actually quite helpful for Mr. Ratzer. Because what that letter said is that if all you were disagreeing with is the blood disorder, you don't need to do anything. But he didn't not do anything. Instead, he reattached his notice of disagreement that we were talking about earlier, and then reattached all of the medical evidence that showed the chain of causation and that these symptoms have been around for decades. So that document further shows that the NOD should have been reasonably construed as covering all the disabilities, Your Honor. If there are no further questions, Appellant rests.
Thank you. The court will hold submission of this case for 14 days pursuant to Judge Allen's suggestion and agreement of the parties, pending discussions between the parties and notice to the court regarding the results of that discussion. There is also a question and answer session at the conclusion of this, and I'd ask the counsel to stay for that as well. Thank you. Come down and recounsel.
All right.